Trademarks are kind of broken up into 4 different kind of areas. So you have the international trademark, you have a federal, state, and then you also have the common law. Now what that means is, from an international perspective, there is no such thing as a true international trademark. What there is an international application that almost every country, barring a few, have signed on to, which is a treaty that says, we have agreed that we will accept a standard application for a trademark, and then you have a period of time to select which countries you want to apply for. So instead of having, so it just simplifies the process. It doesn't necessarily make it less expensive. It doesn't mean you don't have to get a trademark in each sovereign jurisdiction. But for example, if you want a trademark in the US and you also want a trademark in the EU, which has its own trademark, or you can pick France specifically, or you can pick Spain, or you can pick Brazil, you could fill out one trademark application, opt to get it, try to get it approved in each of those jurisdictions, pay their fees, but now you don't have to go through drafting separate ones and doing all of that. As long as it's in English too, you should be okay. Some might require you to translate into their language, but generally you're okay in English for the most part. One of the disadvantages is a little bit less flexible. So because they're trying to standardize one application for all of these countries, there's less mobility and flexibility if you need to change something, if you miss something, if there was a mistake, things like that. The federal trademark, which is the most important if we're doing business in the United States, basically is the biggest benefit that a federal trademark does is it gives you a presumption of doing business in all 50 states, even if you only have one location in one little corner of the town, right? So it gives you that ability to protect yourself from anybody around the country by having a federally registered trademark. And it can be to the tune of you have a little place in Southwest Florida and somebody in Seattle, Washington opens up and it's the same name in the same category of business, you can enforce your trademark and you can stop them and you have every legal right to do that. So the USPTO.gov is the website that manages and maintains both the patents and the trademarks. All the information, everything's on there. When you get a federal trademark, you kind of break it up into 2 areas. You got words and you got pictures. So words is going to be your plain text, so it doesn't matter what it looks like. It's just, you know, if it's Google, it's Google. It doesn't have anything to do with size or colors. And then you have your pictures, which is going to be either like, you know, your Nike swoosh, right, which isn't a word, of course. It's a picture, or you're going to have your colors. So you might have your Google with your big G and your little, you know, your smaller Google and your different colors within that. So that entire picture or entire piece would be the picture of it, if you will. So this is going to be, for most businesses, this is the number one thing that if you're looking to protect your trademark, this is the way you're going to do it in the United States, is by looking to get a federally registered trademark. Now, there are cases where either there's something out there already, there's something similar, someone else registered it, or you just don't want to. And in which case, you get a couple of other options, but they're a little bit less on the enforceability scale. So you can get a state trademark. So most states have the ability to register a trademark within the state. The downfall of it is that there's no statutory protection. So basically, it's a placeholder. It's just the requirements to get it are very low. Basically, is there something else in the state that also has it? Even a federally registered trademark in the state of Florida, if there's a federal trademark, you can still get a Florida state trademark registered. You just have to disclaim and realize that there's a pending application or there's an existing trademark at the federal level. If ever they get challenged, the federal's going to trump the state one all the time. The reasons I recommend sometimes for a client to get this is if they're in a situation where they have a small business, they don't have a federal trademark, another small business opens up across the street or nearby with the same name, they've been in the first business for a few years, let's say. This one's just opening, and they want to enforce their common law trademark, which I'll get to in a minute. And so I will recommend sometimes, let's get a state registered trademark because it adds a little bit of bite to when we send them that letter of saying, hey, you need to change your name because you're infringing on our trademark. We have a state registered trademark, right? So it doesn't necessarily have a lot of bite to it, but it does add a little bit of additional protection in that respect. Your common law trademark, you don't have to do anything to get this. You just have to open up, you just have something in the line of commerce. So that can be a good, a product, a service. So as soon as you start selling it and you put a name onto it, you have what's called a common law trademark. Now this is also going to be a very low level of protection in the sense of when you have a common law trademark, you're basically limited to almost exactly what you're doing and where you're doing it. So for example, if I have a common law trademark on a restaurant and it's in St. Petersburg, Florida, and I open up a restaurant of the same name in Orlando, Florida, you're not going to have much luck enforcing your trademark, right? Now, if it's in maybe right across the bridge in Tampa, might be a different story, right? Now we're getting into how do we argue best to enforce that and make the argument that, look, Tampa Bay is one market, so therefore that's my geographic area and not just a smaller market of St. Pete, right? And that's where the attorneys get involved if that comes to that and makes that argument. There's also no statutory protection. So what we'll get into more as well, but statutory protections, the reason that term is so important is generally it comes with a damage assessment that the federal government has said, okay, if you are found to be infringing on a trademark, then we will set out some sort of minimum damages, and we'll also generally associate getting attorney's fees with that as well. So it's generally statutory protection equals a lot more bite behind it. It also allows you to go directly to federal court. So what that means is that for the other side, both sides, it's a little bit more expensive to litigate in federal court, but it's also much more, most people would rather go to federal court because it's going to be more certainty for the business. State court can get a little bit like a circus sometimes, and we cannot always be sure what's going to happen. Federal court's much more standardized. So we have a much better idea. You still never fully know, but you have a much better idea on how things are going to go. So that's one of the benefits as well.